So it is June, which means it is Pride Month. At least it's Pride Month in Minnesota anyways. And that means the majority of our conversations will be centered around LGBTQIA plus people, places, and things. Now, a lot of our conversations will be coming from my friend's book, Our Gay History in 50 States by Zaylor Stout. And it will also be coming from the 14th Amendment. Yes. Now, this book is in my Amazon storefront, and there is a link in my bio if you want to grab a copy. Now, let's get started with today's lesson, which just so happens comes from this book. If you flip to the state of Mississippi, you will find it. Yes. Let's begin. In 2016, Mississippi State Senate passed the Religious Liberty Accommodation Act, a religious liberty bill that was called the worst yet for LGBT rights. House Bill 1523 was a statewide act that allowed discrimination over sexual orientation and sexual liberty on religious grounds. It allows public employees, businesses, and social workers to deny services based on religious belief that marriage is strictly between a man and a woman. And it doesn't just protect those who hide behind religion. It also covers those who believe that sex should be saved for marriage and that gender is determined at birth. The bill says that the government can't prevent businesses from firing a transgender employee or clerks for refusing to license same-sex marriage couples or adoption agencies from refusing to place a child with a couple who they believe may be having premarital sex. It's letting these people place judgment on other people based on their own belief system or based on religion. Ben Needham, director of Human Rights Campaign's Project One America, said that the measure is probably the worst religious freedom bill to date. Mississippi has gone out of their way to protect homophobes and transphobes. And when I say that they went out of their way, they went the extra mile. According to the Washington Post, the act prevents the government from discriminating through things like taxes, fines, withholding benefits, or other forms of retaliation against a person which is broadly defined as an individual, religious organization, association, corporation, or other kinds of businesses for acting on their religious convictions regarding sexuality and marriage. That includes employers, landlords and rental companies, adoption and foster care agencies, people and companies that provide marriage-related services. Essentially, anybody who breathes. And it gets worse. The bill protects doctors who refuse to provide counseling, sex reassignment surgery, fertility treatments, and other services based on their religious conviction, and allows companies and schools to establish sex-specific policies regarding dress and bathroom use. It allows state employees to recuse themselves from licensing or overseeing a same-sex marriage so long as they take all necessary steps to ensure that the marriage isn't impeded or delayed as a result. And it gives foster and adoptive families license to guide, raise, or instruct children as they see fit. It gives foster and adoptive families license to guide, raise, or instruct children as they see fit. You heard me correctly. A rule that Human Rights Campaign argues would make LGBTQIA plus children vulnerable to being forced into conversion therapy. And the hooker who sponsored this, Jennifer Branning, she says, this is presenting a solution to the crossroads we find ourselves in today as a result of Obergefell versus Hodges, which says same-sex marriages are recognized under the 14th Amendment. If it's recognized under the 14th Amendment, that makes it what? Constitutional. What they're doing is not constitutional. And because the Supreme Court said that same-sex marriages are constitutional, Mississippi said, hold on, let me find a way to allow my people to be homophobic and transphobic. Give me a second. I can find a way. Branning says it takes no right away from anyone. It gives protections to those in the state who cannot, in good conscience, provide services for a same-sex marriage. How is a clerk refusing a marriage license to a same-sex couple not taking rights away when they are being refused a right that the Supreme Court says was constitutional under the 14th Amendment? How is that not taking their right away? And then she says, ministers, florists, photographers, people along those lines, this bill would allow them to refuse to provide marriage-related business services without fear of government discrimination. Government discrimination, government discrimination. Does that woman know that that is an oxymoron? Because the government cannot discriminate. That was determined long before any of us were alive. Individuals can discriminate. Government, local and federal, cannot. Governor Phil Bryant signed the bill into law April 5th, 2016. He didn't think that the bill was discriminatory. Of course, he wouldn't. He was like, House Bill 1523 singles out 3 sincerely held religious beliefs as worthy of protection, that marriage is between one man and one woman, that people should not have sex outside of marriage, and that a person's gender is set at birth. Now, an injunction was filed to stop the act from going into effect. And on June 23, 2017, the Fifth Circuit Court of Appeals lifted the injunction, allowing the law to go into effect. The U.S. Supreme Court refused to take the case any further. So the law is in effect. I want to remind you that Mississippi has the reputation for being the most racist state in the Union. And so I guess now we are adding the most homophobic and transphobic too.